September 6th, 2012 is justice done dirt cheap at the so-called Justice Building. Have a hearing coming up and spent the day running around filing documents, serving documents, doing some procedural preparation for the hearing coming up on Monday, September 10, 2012. Now I'm just going to show you what I have here. This is a cover letter that, as you can see, is stamped September 6, 2012 by the clerk's office. If I can keep the wind from blowing too hard here. As you can see, it's addressed to Craig Carlton, clerk of the Court of Queen's Bench in New Brunswick. And you can see the style of cause at the top of the document, which gives the court file number. Reads in the Court of Queen's Bench in New Brunswick, Trial Division, Judicial District of Fredericton. Because that's where we're at, is Fredericton, between Andre Murray and the City of Fredericton and others. Now, this is a cover letter, so it's known as a cover letter. Basically, one puts it on the top of their documents so that it's easy for the clerk to review the documents. So he can read the letter and it says, please find enclosed. It lists the documents that are there, so it's easier for the clerk or whoever's assisting the clerk to file the documents in the appropriate files and or get them to the judges who need to review the material before an upcoming hearing. Now, as you can see here, this shows affidavit of service by Andre Murray dated September 6, 2012. And what's interesting is that this morning, I'll give you a quick run through of what I had to do today. So this morning I filed a brief to be used on a motion that's going to be heard on Monday. Now, though the rules of court do not require it, one may file a brief to be heard on motion. The brief is your written argument that gives the case law, your written legal position for the judge to consider. If one's brief is done well enough, there's nothing further that needs to be said at the hearing. You just rely on your brief, and that's it. What's great about a brief is one has the opportunity to write down their thoughts in a very coherent, logical manner. Things go from top to bottom through the document. You can address all the different topics that are going to be considered at the hearing, and provide quotations of all the relevant case law that supports one's legal position. Now, what I had to do this morning was I had to file a brief. Now, the rules of court do not require a brief be filed 48 hours before the hearing, but for some reason the court in Fredericton made a declaration one day that was going to happen no matter what, and decided to unilaterally change policy of the clerk's office in Fredericton. After that, the clerk of the court has administered a policy that is very strict. I've had my documents rejected if I was less than 48 hours, and I mean 10 minutes over the mark. If my hearing's on, as an example, if I had a hearing 2 days from now at 9:30 a.m., I would have to have everything filed by 9:30 a.m. today. If I was there 9:40 a.m., which has happened to me, my documents were rejected because I was late. If you're going to be late, call in ahead and say who you are, say what documents you're filing, and you will be a few minutes late, or however long it's going to be that you're late, so that you don't have your documents rejected on a technicality. It's a real sad state of affairs when one spends hours and hours and days researching a specific topic to get those cases that support one's legal position, spend a lot of time writing a draft of a legal argument, then rewriting it till it's finally complete, and after spending all that amount of time, it's rejected on a simple technicality of a few minutes late, when the rules of court do not even require that documents for a motion be submitted 48 hours before the hearing. But anyways, that's the state of affairs in Fredericton, New Brunswick, this September 6, 2012. So, to avoid wasting all that time, I made sure I filed the documents on time And after filing my brief, which received a court file date stamp on it, and also an affidavit which I plan to use on the same hearing of the motion, I had a date stamp on both, and I made photocopies of those documents and then served the recipient party. The receiving party was Solicitor Deborah Lamont for various named defendants, most notably the City of Fredericton Police Force, and several actually named Fredericton Police Force members. Now, what's interesting with this motion is that what Deborah Lamont, actually no, let's see, the solicitor representing the party in this case is Leanne Murray. I pardon me for that misspeak there. So the solicitor representing the City of Fredericton and others is Leanne Murray, who works at McGinnis Cooper on Queen Street, Fredericton. And what she has done is she filed a motion that is requesting the court to impose a monetary, basically, fine against me, where I would have to prepay a certain dollar value, which is usually 2/3 of costs awarded against a party, before I could actually move on to appeal. And just to give a brief recap here, what happened is I filed an action against the City of Fredericton and others because of two incidents that occurred. One, I was traveling by bicycle. The Fredericton Police Force members stopped me. 3 cars converged to my location. They dragged me off my bicycle, slammed me on the trunk of a car, went through all my belongings, arrested me, handcuffed me, tossed me in the back of the car, held me for some time, and all the while there was a spectator in an unmarked police car watching this event, and that was defendant Trina Rogers. It's very unusual for someone to show up, as in not a member of the Fredericton Police Force, to such an event. I thought it was unusual. I did practice due diligence, and I actually filed a right to information and protection of privacy request through the RTI PPA of New Brunswick, and through what was disclosed, I found out that the reason why the police arrived in the first place was because someone called the police, said there was something or other illegal going on, gave a description, gave basically my description, and that's why the police came after me. Now, I believe it was Trina Rogers who called the police. That's why she was there that day. A second event occurred that's part of the same litigation. Is in 2009, I was simply shoveling my driveway of my residence. The Fredericton Police Force arrived. I was quickly tackled, put through all kinds of pain compliance maneuvers. If we were to do it, as in the regular citizens or civilians do it, it's called torture and battery or assault. But when the Fredericton Police do it, they call it pain compliance. So all kinds of pain compliance techniques were practiced on me that day. Then they finally pepper sprayed me, handcuffed me, dragged me off to the Fredericton Police Station, held me for some time, then released me without charge. I again did a right to information and protection of privacy request through the provincial legislation, the RTI PPA, and found out that the reason why the Fredericton Police Force arrived was because someone called the police, said there was something illegal or other going on, and there was a fugitive from justice that the Fredericton Police Force should apprehend. That's why the Fredericton Police Force arrived and tackled me. So these two events, which are highly unusual, caused me considerable damage. It took months of recuperation from each injury, or each event had various injuries. It took months to recuperate from, and I'm not fully healed even to this day from some of those injuries. And it's wrong that the Fredericton Police Force acted the way they did. It's wrong that they conduct themselves in such a manner. Even if someone calls in and provides fraudulent misrepresentations, they should act with due diligence and according to the law, not acting like cowboys. So what ended up happening is I filed an action against all these various parties. What the City of Fredericton solicitor Leanne Murray did was filed a bunch of preliminary procedures where if I didn't respond in time, the whole matter was going to get thrown out on a technicality. So I spent a lot of time filing paperwork to keep up with the various demands of me as a litigant. And what ended up happening is Leanne Murray filed on behalf of the City of Fredericton and others 2 motions to dismiss the action for various reasons. Now, the self-represented parties, Trina Rogers and Neil Rogers, both filed an identical motion. It's word for word the same. They just replaced their name, the members of the Fredericton Police Force names, with their own, and just changed minimal amount of material. Now what ended up happening is, after the hearing, which was 4 motions were heard on the same hearing, which is not enough time. It was only 2.5 hours scheduled. This is just insufficient time. It was rushed. The judge would not allow me to speak, would not allow me to be heard. I was cut off, and what ended up happening was the court ruled against me after some months of waiting, and ordered over $10,000 in cost ordered against me in favor of these other parties. So I appealed that decision, naturally, because the judge's decision, the written decision, was just full of errors in law, errors in fact, misapprehension of the facts. It's one of the should be most easily overturnable or appealable decisions in the history of New Brunswick. It's really that bad. And judges have good days and bad days. They make mistakes, and that's what the Court of Appeal is for. Is so that errors in law can be corrected, so we're not subject to judges making bad decisions because it was a bad day. Now, what the city solicitor, Leanne Murray, has done is filed a motion asking the court to make an order demanding that I pay 2/3 of the cost ordered in the favor of the city of Fredericton, or I don't go to appeal. So if you think about this, I would have to prepay almost $6,000 in costs before I can even go to appeal, or the action is considered stayed, or my appeal is deemed abandoned. And what's amazing about this is I'm appealing the cost decision. I'm saying that cost order is wrong. It's not based on any recognizable legal principles. The decision does not reflect the merits of the argument or the evidence presented. It's just terrible. Now, for the solicitor, Leanne Murray, to go ahead file a motion like this, putting a cost bar on me, which basically prepay to continue on to appeal, is just wrong. One should not be barred from meaningful relief from the courts by these financial trickery and legal sleight of hand, so to speak. Whereas this, let's just go to appeal, see if the Court of Appeal decides whether the decision was wrong or not. If the Court of Appeal finds in my favor, I don't have to pay any cost whatsoever, and hopefully the cost order will be reversed. That would mean $10,000 going towards me in my favor. Yet, with that decision pending, they want to have me prepay over $6,000 in costs, which doesn't make any sense whatsoever. I don't agree with it. I believe it's just further manipulation of the justice system against a self-represented litigant, and it's wrong they're doing this. So I just wanted to give you an update what was happening today. So in the morning, I filed both the brief to be used in the same motion, an affidavit in support of it. Then I served that motion and brief on Leanne Murray's office. Then I filled out an affidavit of service and some cover letters. Had that sworn out, and then filed the affidavit of service same day, so there's not some complaint about me not getting things in on time. Anyways, thank you for listening. It's Justice Dunder Cheap in Fredericton, New Brunswick, September 6, 2012. Just filling you in on some legal procedural matters and a little bit of a recap on my current legal situation. Continuing the fight through the New Brunswick court system. Thank you for listening.